are you guys today?
Good morning, everybody, and let me start the Oversight and Investigations Subcommittee this morning. And I have my start with an opening statement, but I would say because the House is having some early votes this morning, I ask unanimous consent that the written opening statements of all the members be introduced to the record. Without objection, the document be entered into the record. My colleagues, today, after 8 months of investigation, the Subcommittee on Oversight and Investigation will examine the Federal Communications Commission's decision and orders relating to LightSquared and the Committee's efforts to build a wireless mobile broadband network. The controversy regarding LightSquared and its efforts to build a national wireless broadband network revolves around a piece of spectrum called the L-band. This band of spectrum has historically been reserved for satellite services. In 2003, in order to encourage more efficient use of the band, the FCC issued an order permitting mobile satellite service providers to integrate an ancillary terrestrial component or land-based component into these networks as long as they met certain requirements. Since that time, LightSquared and its predecessors have been involved in multiple proceedings before the FCC involving the development of its terrestrial component. During these proceedings, LightSquared reached agreement with GPS companies about, quote, out-of-band emissions, end quote, that may result from its terrestrial-based stations and invested approximately $4 billion in its network. In March 2010, the FCC approved the transfer of SkyTerra's L-band licenses to LightSquared, enabling the company to deploy a nationwide broadband network. And this transfer was conditioned on LightSquared meeting an aggressive build-out schedule and agreeing not to provide service to the nation's two largest wireless carriers. In January 2011, the FCC granted a conditional waiver allowing LightSquared's customer to access its network using devices only capable of receiving terrestrial signals. The waiver was conditioned on LightSquared resolving an overload interference issue raised by the GPS community. These interference issues were a different technical concern that out-of-band emission problems that had been raised by the GPS community in prior proceedings. A technical working group was formed to examine the overload interference issues affecting GPS receivers. NTIA later charged PNT XCOM with validating the testing. In February, NTIA concluded that LightSquared's system would cause unacceptable interference to GPS. Only 1 day later, the FCC moved to revoke its conditional approval of LightSquared's plan to build a 4G wireless broadband network, leaving the company and its Spectrum holdings in regulatory limbo. That is where we stand today. LightSquared, a company that committed billions of dollars and years of time in developing its network, has filed for bankruptcy. Its 40 megahertz of spectrum is left unused at a time when demand for wireless service and broadband is exploding. We have convened this hearing today to determine whether this could have been prevented. This hearing also raises important implications for spectrum policy going forward. Regulatory uncertainty at the FCC will deter new innovative ideas and competition in the mobile space. Moreover, it is not sound spectrum policy to allow 40 megahertz of spectrum to sit fallow while at the same time seek to relocate broadcasters and federal users off their spectrum holdings to free up more space for wireless use. So I look forward to the testimony of our two witnesses today, and I recognize the Ranking Member, Mr. Gett, for an opening statement.
Thank you very much.
Oh, just a moment. I think we're going to just take 5 on this side and 5 on your side.
Fine.
So I'll go to Dr. Burgess.
I thank the Chairman for yielding. I thank the witnesses for being here today. I'm grateful we're having the hearing. I know my constituents appreciate it. So the expansion of the 4G cellular networks to a portion of radio spectrum traditionally reserved for mobile satellite communications would improve mobile satellite communications and benefit U.S. consumers needing more bandwidth for communication. But somehow, somewhere along the way, things went off track. The FCC obviously has the obligation to be the caretaker of the electromagnetic spectrum. The question is raised, did they do their job? The decision to grant LightSquared a conditional waiver order on January 26, 2011 does seem to be ill-advised. The period for public comment before the granting of the conditional waiver order was brief, And whether it was intentional or unintentional, it was placed in the middle of the holiday season the year before. Requests for an extension of the period for comment were not honored, and a decision was made in haste over the objections of the United States Air Force and the GPS industry itself. Benjamin Franklin said, haste makes waste. In the operating room, we have a saying, go slowly, I'm in a hurry. This time it seems that haste was, in fact, the enemy of good decision-making. The FCC attempted to address the concerns through the formation of a government and industry working group, but the solutions have not proved up to the task. I hope today's testimony will shed light on these events. Mr. Chairman, I thank you for the recognition. Now yield back.
Now I recognize the ranking member, Mr.
Thank you very much, Mr. Chairman. I really want to thank you for having this hearing today on LightSquared and expanding access to broadband, which we all agree is a key driver of economic growth for our nation. This administration has taken unprecedented steps to accelerate deployment of wired and wireless broadband networks, and the FCC has been a key partner in that effort. Mr. Chairman, as you said, the policy issues today are important, and LightSquared and the GPS dispute deserve our scrutiny. Several other House committees have already looked at this issue over the last 2 years, and so as the committee with primary jurisdiction, I wish we had looked at it sooner, but I'm glad we're going to hear from the FCC witnesses today. These are experts who are widely respected for their knowledge and expertise, and I know we can learn a lot from them. Mr. Chairman, in a lot of ways, the FCC was put in a no-win position. This was a difficult decision for them, and no matter what the agency did, someone was going to end up being very unhappy. And I don't know about you, but I certainly don't have the technical expertise and detailed knowledge to be in a position to second-guess the FCC's decisions in this, but I do think we can look carefully at the FCC's decision-making process. And I think the committee's investigation has revealed a regulatory review process working as it should. LightSquared was licensed to use spectrum to provide communication service. Over the years, LightSquared sought approval from the FCC to move ahead with its plans, and at every step of the way, the FCC solicited and received public comment on the committee's proposals. Under both the Bush and Obama administrations, LightSquared received approvals from the FCC to create and modify its business plans to build a network. During the approval process, public safety concerns with GPS receivers were brought to the FCC's attention. The FCC warned LightSquared of these concerns and only gave a conditional approval to the company to move ahead. Then they set up a process to let technical experts determine if these concerns were meritorious. The FCC made the decision to retract LightSquared's waiver only after the experts found that, quote, there is no practical way to mitigate the potential interference, end quote. The FCC took the responsible steps that one would expect in order to address this problem. The agency conditioned its FCC clearly told LightSquared that it would have to solve interference problems before it was allowed to move forward with its plan. FCC set up a technical working group to explore problems and made sure that all stakeholders were represented. When experts concluded that there were continued risks from deployment of the LightSquared network, the FCC took preventative action to ensure public safety. As of today, LightSquared has offered alternatives to move ahead, and I hope they work, by the way, and the FCC remains open to exploring viable solutions. Now, Mr. Chairman, it's not Congress's role to make these kinds of detailed technical decisions. I don't have the expertise to do so, and nobody else on the committee does. That's why Congress gave the authority to the FCC in the first place. I would be concerned, of course, if the FCC made a politically motivated decision or was swayed by political process, but I don't think anybody here thinks that that's the case in this situation. Instead, we have the FCC weighing the pros and cons and making a very difficult decision based on the advice of the technical experts. I appreciate our witnesses being here, Mr. Chairman, and I want to take just 1 minute of personal privilege. This might be the last hearing that we have in this Congress in the Oversight and Investigations Subcommittee, and I just want to say on a personal note how much I have enjoyed serving as ranking member with you, Mr. Chairman. We haven't always had calm and sedate hearings in this subcommittee, but we've always had respectful discourse, and we've always had debates and investigations that have attempted to shed the light on things. And you know, I've said, probably you've heard me say every single hearing we've had, I've been on this subcommittee for 16 years, and I've enjoyed serving with all of my chairmen. This chairman is no exception. I know I can speak for the entire side of my aisle in wishing you Godspeed and all success in whatever you decide to do in the future, Mr. Chairman, and I yield back.
Well, I thank my colleague, and she and I both know how much we've enjoyed our friendship here, and it's beyond just the hearing, and we've talked to each other on the floor many times, and we were friends even before I was chairman of this committee, so I appreciate your salute and felicitations, and I appreciate our friendship after I'm gone, too. With that, let's recognize the two witnesses here. We have Ms. De La Torre, who is serves as chief of the International Bureau at the Federal Communications Commission. She was previously served as deputy chief of the Telecommunication Division of the International Bureau. She was president of the Telecommunication Management Company in Washington, D.C., and she has a B.A. from Vanderbilt and a doctorate from the University of Texas. We have Mr. Julius Knapp is chief of the FCC's Office of Engineering and Technology. He became chief in 2006, having previously served as deputy chief since 2002. He has a bachelor's degree in electrical engineering from the City College of New York. At this point, let me swear each of you in here. I think we've got the... As you know, the testimony you are about to give is subject to Title 18, Section 1001 of the United States Code. When holding an investigative hearing, this committee has a practice of taking testimony under oath. Do you have any objection to testifying under oath? No? The chair then advises you that under the rules of the House and the rules of the committee, you're entitled to be advised by counsel. Do you desire to be advised by counsel at this time? Okay. In that case, you please rise and raise your right hand. I'll swear you in. Do you swear the testimony you're about to give is the whole truth and nothing but the truth, so help you God? I do. We now welcome your opening 5-minute testimony. Start with you, Ms. De La Torre. Okay. Mr. Knapp, go ahead.
Good morning, Chairman Stearns, Ranking Member DeJette, and members of the Oversight and Investigations Subcommittee. My name is Julius Knapp, and I'm the Chief of the Federal Communications Commission's Office of Engineering and Technology, where I have served for 38 years. OET is the Commission's primary...
Let me ask you, just pull the mic a little closer. Sure. Yeah.
Thank you.
Yeah.
OET is the Commission's primary resource for engineering expertise and provides technical support to the Chairman, Commissioners, and the FCC's bureaus and offices. I appreciate this opportunity to join my colleague, Mindell De La Torre, Chief of the International Bureau, in appearing before you today. My portion of the testimony will focus on the FCC's role in evaluating and attempting to resolve spectrum interference issues in connection with the mobile satellite service in the L-band. Ms. De La Torre will address the process and historical context relating to granting ancillary terrestrial component, or ATC, authority to mobile satellite or MSS providers. At the Commission, we are focused on ensuring that businesses and consumers are able to take full advantage of the economic opportunity presented by underutilized spectrum, but only when consistent with public health and safety. In its decade-long proceeding to remove regulatory barriers and align the service rules for the L-band with the rapid evolution of mobile communications technologies and markets, the Commission considered a unique proposal that had the prospect of attracting new investment, increasing competition, bringing additional broadband service to rural and hard-to-reach regions, and creating thousands of jobs. This proposal was the direct result of proceedings designed to ensure that MSS spectrum would be utilized to its full potential. As with any proceeding before the Commission that has a potential for spectrum interference with nearby spectrum users, the FCC relies on licensees and stakeholders to raise any relevant interference concerns. During the decade preceding the LightSquared's November 2010 waiver request, the GPS industry had numerous opportunities to inform the Commission of the receiver overload issue. Despite participating extensively throughout these proceedings and raising other interference issues that were ultimately resolved, it did not do so. The FCC would have investigated any potential interference issues as soon as they were raised and attempted to resolve them. Nevertheless, once GPS receiver manufacturers and service providers ultimately informed the Commission of the potential for interference to legacy devices, the Commission halted the licensee's proposed commercial service. To be clear, in November 2010, the GPS industry was not complaining about signals from LightSquared signals falling into the GPS band. They were instead notifying us that GPS receivers would pick up signals far into the neighboring band. In responding to those GPS concerns, the Commission acted responsibly under its 70-year Memorandum of Understanding with the Department of Commerce to protect national security and public safety, while simultaneously attempting to find a solution to the GPS receiver overload issue. The Commission's goals in proceedings such as these are to foster cooperative engineering solutions to what sometimes seem to be impossible problems. We worked equally with all of the interested entities, including NTIA, the Department of Defense, other federal agencies, and the GPS Industry Council, to assess LightSquared's proposal and to encourage the parties to work together to resolve this matter. This process has been fact-based, transparent, and in accordance with the Commission's established policies and procedures. Now, as I've mentioned, in this instance, the interference is caused by GPS receivers picking up signals outside of the GPS band. The Commission relies on receiver manufacturers and service providers to report potential interference issues because they are in the best position to understand the parameters and limitations of their own equipment. The Commission does not possess the technical specifications for the hundreds of different types of GPS devices utilized by commercial users, government contractors, and government entities. Moreover, since the FCC does not regulate GPS devices, we are not prepared to test such devices or determine their capabilities and interference issues. Manufacturers and service providers have the relevant information, and they also have the incentive to notify the Commission of the potential for receiver overload so as to avoid problems with their services and products. The lack of technical data provided in response to earlier Commission proceedings prevented us from addressing that issue until well after permission had been granted in 2003 for MSS providers to use the L-band for terrestrial service. Again, thank you for this opportunity to appear before you, and I look forward to your questions.
Thank you. Ms. De La Torre.
Good morning, Chairman Stearns and Ranking Member Daggett and members of the Oversight.
You might have to pull the mic just a little closer, too, if you don't mind.
So, good morning.
Super.
My name is Mindell De La Torre, as we've said, and I'm Chief of the International Bureau at the FCC. I'm pleased to have this opportunity to follow my esteemed colleague, Julia Snapp, in providing you the background and context related to the FCC's process in the MSS ATC L-band matter. I've been Chief of the International Bureau since October 2009, where I oversee the Bureau's functions with regard to licensing of international and domestic satellites, international long distance, international broadcast stations and submarine cables, as well as the FCC's participation in bilateral and multilateral efforts. I previously worked at both the NTIA and the FCC, and I appreciate the two distinct roles that these agencies play in ensuring adequate spectrum for America's consumers and governmental entities. As my colleague mentioned, that Commission is focused on lifting regulatory barriers and ensuring economic growth. The MSS ATC L-band proposal, filed with the International Bureau in March 2009, represented such an opportunity. However, when we were informed that there was a potential for receiver overload interference from the GPS community, we took action to ensure that these essential U.S. services, government services, as well as commercial activities would not be disrupted. The detailed summary in my written statement and the attached appendix outline the Commission's 10-year history in the MSS proceeding. The Commission's consistently, across the tenures of three chairmen, worked to promote terrestrial use of MSS spectrum. This history further shows that the Commission acted in accordance with established procedures and allowed multiple opportunities for public participation. Also, the Commission staff exercised delegated authority only where consistent with Commission rules and provided at least 48 hours advance notice to individual commissioners to inquire about these decisions. The proceedings relevant to this hearing began in 2001 when LightSquared's predecessor in interest, Mobile Satellite Ventures, MSV, along with ICO Global, petitioned the Commission to allow for the addition of an ancillary terrestrial component, ATC, to integrate terrestrial services with their mobile satellite services. These parties argued to the public that the public would benefit from the terrestrial component because it would enhance coverage in areas where reliable satellite service was challenging. In 2003, the Commission approved rules to permit MSS licensees to operate up to 1,725 base stations, and in 2005 this limitation was lifted, to provide mobile service to areas where satellite signals are degraded or blocked, specifically urban areas and inside of buildings. The U.S. GPS Industry Council filed a petition for reconsideration of that out-of-band emission rules, noting that the rules failed to adopt emission limits specified in the 2002 agreement. USGIC noted that the limits were necessary to protect against the potential deployment of tens of thousands of cell towers and millions of mobile devices. The receiver overload issue, however, was not raised in this proceeding. Over the course of the next 8 years, the Commission engaged in several actions designed to foster MSS ATC deployment. The record shows that the GPS industry consistently failed through several proceedings to specifically notify the FCC of receiver overload problems or concerns, until briefly referencing the issue in comments related to the July 2010 MSS Notice of Proposed Rulemaking and Notice of Inquiry, and then again in response to the November 2010 waiver request. In the interim, the Commission provided MSS ATC authority, set power limits, and other operating parameters, as well as acted on the transfer applications, ultimately leading to LightSquared status as a licensee. On January 26, 2011, the International Bureau responded to the concerns raised by the GPS industry and other parties by preventing LightSquared from deploying commercial service in the L-band until it resolved concerns about harmful interference. The Bureau did so through a conditional waiver order that also directed LightSquared to organize and participate in a GPS interference technical working group in which all interested parties would work directly with LightSquared to resolve the interference concerns. The technical working group included more than 120 participants, including representatives from the Department of Defense and other federal agencies, as well as the GPS community and various telecommunications companies, and of course LightSquared itself. On June 30th, 2011, LightSquared filed the final report of the technical working group with the Commission. And based on these results, LightSquared recognized that in its proposed use of part of its spectrum, what we call the upper 10 megahertz band, would result in GPS receiver overload. LightSquared offered an alternative proposal to operate only in the lower 10 megahertz band and to coordinate and share the cost of underwriting a workable solution for GPS legacy precision measurement devices that were at risk of overload. The FCC released the technical working group's report, as well as LightSquared's alternative proposal, for public comment on June 2011, and subsequently required further testing. On February 14th, 2012, the Commission received a letter.
If you can just sum up.
Okay. And so the Commission staff is currently reviewing the extensive record developed in response to the public notice. Currently, LightSquared still cannot deploy its service commercially because of the unresolved receiver overload interference issue. And this concludes my testimony.
Thank you. And I'll start with my questions. And Ms. De La Torre, I'm going to ask you a question. If possible, you could just answer yes or no. In an August 4th, 2011 email marked as Exhibit 1 in your binder, you made an analogy, the LightSquared GPS situation, determining interference, the interference dispute on the highway, where LightSquared is operating, and this is what you indicated, is operating in the left lane and GPS is operating in the middle lane. You state that GPS, quote, has been driving in the left lane with impunity, but now that it looks like the left lane might actually have traffic in it, the GPS community is yelling bloody murder, end quote. Is that true? Is that what you wrote?
I did write that.
Yeah, okay. Each operator has a responsibility to stay in its lane, using your analogy. Is that correct?
Yes.
And when one operator veers into the adjacent lane, is it the responsibility of that operator to correct its course, or is it the role of the FCC to patrol the highway? Briefly.
Really, what was happening here was that
Isn't the responsibility of the operator to correct its course? Yes or no?
that's a difficult question. That's the question that's before us, and I think
Yes or no?
Can't you let her answer it?
No, I'm asking for a yes or no. To your best of your ability.
Well, I think that they do have a duty to respond.
Okay, I'm going to take that as a yes. Does GPS companies have a duty to design receivers that filter out signals in adjacent bands? Yes or no?
I'll let Mr. Knapp, who's the engineer.
Well, you can answer too.
That question.
Based upon your email, I would say your answer would be yes. They have a duty to design receivers that filter out signals in adjacent bands. Is that a correct? Say yes? Okay. Mr. Knapp, I'm ready for you now. You state in your testimony some GPS legacy equipment effectively treats the GPS spectrum and the L-band spectrum as one band. Is that true?
That's true.
Since the problem appears to be a GPS devices and not LightSquared's emission, what does this mean for the future of the L-band?
So the difficult issue we have is all of the millions of legacy devices that are out there, relied on for things like public safety and so forth, and there's no easy way to fix many of them. So we absolutely do need to be thinking about what we do going forward, and we're doing just that.
If GPS does not make changes to its wide front-end receiver devices, do you envision a scenario where anyone could operate in the L-band in the future?
I think what we're trying to
If they do nothing, is the L-band available?
Well, for the high-power equipment that's been proposed, the issue of the upper 10 is problematic. The lower 10, I think, is still subject to our open proceeding.
But wouldn't you say, based upon what I just said, that this L-band is going to be in jeopardy if there's not some type of effort by GPS to make changes to its front-end receiver? Isn't that true?
I think what we need to do is
Yes or no?
It would be yes.
Okay, yes. Ms. De La Torre, one day after receiving LightSquared's updated business plan and request for a waiver of the Integrated Services Rule on November 18, 2010, the FCC placed the request on public notice, providing a 10-day period for initial comments. How many days does the FCC normally provide for comments after issuing a public notice for ATC modification request? Put your mic on.
Anywhere from 7 to 21
Okay.
days.
Was the expedited comment period relating to the FCC's March 2010 order requiring that LightSquared follow an aggressive built-out schedule for its network?
Well, they had this proceeding, as I mentioned, had been going on since 2001, so there was a lot of documents in the record. So we put it out for public notice for
Okay.
this.
Does anyone request an extension of the comment period? And if so, who? And was the request granted?
Yes, there were requests for extension, and we did grant that extension. We granted the extension for 3 days.
Did the parties requesting an extension have a chance to actually file their comments in the proceedings?
Yes, they did.
There are many concerns I have with the process, but the greatest concern I have is that your agency, acting only on one day after the NTIA sent their comments to the FCC, rushed through a public notice that would put LightSquared in regulatory limbo with no alternative in sight. Can you explain to me why the FCC did not first look to alternatives short of proposing to suspend the company's licenses?
What we wanted to do is we wanted to get public comment as much as we possibly could on this important report that we had gotten from NTIA and the letter from NTIA. We wanted to get as much comment as we possibly could, so we put it out as soon as we could.
But acting only one day after NTIA sent their commitment to the FCC, it seems like you rushed it.
don't know that we rushed it, but we were definitely, we wanted to get as much information as we possibly could.
I'm anxious for the FCC to reach a conclusion on this matter and continue to hope that a solution can be found. When do you plan to wrap up your review of your February public notice?
So we don't have a specific target. It's a complex issue, and LightSquared has put some new ideas on the table, and we think everything is worth considering at this point.
All right, my time's expired.
Thank you very much, Mr. Chairman. Ms. De La Torre, I just want to clarify your answers to the previous questions. This memo, this August 4th, 2011 memo, Exhibit 1, that the chairman was referring to, I think it would be fair to say that what happened here was that the spectrum was allocated in a certain way so that the GPS had a certain portion of the spectrum, correct?
Yes, that is correct.
And LightSquared had been approved conditionally for portions of the spectrum that were adjacent to the GPS portions, correct?
Yes, dating back to 2004.
Yes, and after the conditional approval, the GPS community came forward belatedly and told the FCC that they were concerned because they were actually going into portions of the spectrum that LightSquared had been conditionally approved to use. Is that correct?
There had been an order that had been, the transfer of control order from Skyterra to Harbinger had been issued the year before in March 2010. And with that order, there was another accompanying order that modified the license. And so that had happened earlier in the year.
But you were frustrated when you wrote this memo because the GPS folks were supposed to stay, as you said, in their lane, but they consistently went over into the other lanes that had been conditionally authorized for others, right?
I think
yes or no would work with this one. Thank you. But you also recognized in this memo, in the part that the chairman didn't refer to, that the problem here is that GPS, and I want to ask you about this too, Mr. Knapp, because there have been some glancing references to it, but this GPS wavelength is very important security-wise. Is that right?
Yes.
Absolutely.
So Mr. Knapp, in your testimony, you said that there are concerns about national security and safety with GPS. Is that right?
Of course.
And Ms. De La Torre, in the end of your memo, you say, quote, "This is a very complicated issue and tough choices will need to be made and may in fact change the established rules of the road. But how many times do we have to reiterate, we will not endanger one person on an airplane, one soldier, one voter, or one driver who relies on your GPS service." Is that what you said in the memo?
Yes, I did.
And that's because even though it's irritating that maybe GPS is not staying in their lane, if you literally hold them to that, then and there's some problem with this GPS, then it could affect national security, communications, or transportation, like airplane communications. Is that correct?
Yes,
Mr. Knapp?
Yes.
Okay. So I can see why you'd be frustrated because poor LightSquared, they've got this conditional approval, and through no fault of their own, the GPS is going over into their lane. And I think that's why your review process is still open, because you're still trying to find a solution to it. Is that correct, Ms. De La Torre?
Yes, absolutely.
And so here's my question. I know that LightSquared has come forward with some other proposals to use different parts of the spectrum and so on. Are you considering those other proposals right now?
Yes, as Mr. Knapp said, yes, we are currently considering.
Mr. Knapp?
If I may.
Sure.
I should add that several of those proposals include spectrum that's used by the federal government, so the federal side, NTIA, would have the lead in determining whether those are viable.
correct? In order to make that determination, do you need congressional action?
No, at this juncture, I can't project whether that would be necessary or not, but certainly we would come back if that seemed to make
Okay, so it's not like, and either one of you can answer this. It's not really like the FCC is trying to arbitrarily sabotage this investment that LightSquared has made, which is substantial, correct?
Absolutely not.
And in fact, you're still trying to find a solution. Is that right?
That's right.
Okay. I don't have any more questions. Thank you, Mr. Chairman. I yield back.
You got 1 second left. You want to ask him if there is a solution?
You can ask.
I'll take your 1 second. Is there a solution?
There are ideas that are worth considering. Whether they will.
So the answer to the question is yes, there's
Yes.
a solution. Yes, there's a solution. Okay, thank you. With that, I recognize Dr. Burgess for 5 minutes.
Thank you, Mr. Chairman. Now, Mr. Knapp, you said worth considering twice. So it's intriguing. This is an enormously complex issue, made even more complex by now I've got mental images of double wides and windy mountain roads. But, you know, I think that's really what the committee is asking is about a solution, and a solution that where both parties can actually come away with something. Neither party is harmed to the extent that they can be kept from harm, and we don't tread upon the rights of other people who have reasonable uses for spectrum that already exists. Is that a fair statement?
That is a fair statement.
Well, then, in the things that you have that are worth...
Dr. Burgess, can you just pull your mic up a little bit? Just so it's easier to hear you. We're waiting on every word you say, so we got to hear it.
Well, in that context of having things that are worth considering, surely you have some solutions that you've been pushing back and forth between yourselves at the FCC. Are there any of those that you're willing to share with the committee this morning?
Not specifically. I will say, but it's not only this immediate issue, but we also think long term about the implications for use of this spectrum because of the spectrum crunch and the importance of getting every ounce of benefit out of all of the spectrum that we possibly can.
Well, we certainly bump up against this from time to time in this committee because of the fact that the spectrum is a valuable asset owned by the people of the United States. The government's in a cash crunch, so sometimes we actually go to spectrum as a solution. Let me just ask a couple of process questions of both of you, and I referenced this in my opening statement. The comment period before the issuance of the conditional waiver, it does seem to be condensed, especially when you're dealing with an issue of this complexity. Is that a fair observation for me to make? And bear in mind, I'm just a simple country doctor. I'm not an engineer. So it just seems like that was, you drop it before Thanksgiving or between Thanksgiving and Christmas. It looks like Harry Reid's health care bill to me. That's not a time where a lot of people are paying attention.
Mm-hmm. If you view this in the broader context of the long history of the proceeding, we had a commission rulemaking proceeding that set out the policies that were to apply here. What the staff was doing was just implementing those policies. There already was provisions for a substantial terrestrial network. And if you look at what action was actually taken, we took the very tough step of saying that the system could not be operated commercially until this issue was resolved. So, and we put in place a process to understand the scope of the problem and try to find a way to get solutions to it. So although the specific time frame of the action may have appeared in isolation as short, what we were doing was moving as quickly as we could to a process to find an answer.
And yet, some of the principals involved, the GPS industry, the Air Force, did seem to feel that there wasn't adequate time. Did they not? Did they not express that to you?
So what we did in the action, they had asked that we needed time for further tests, so the process we put in place did just that. And we made sure that those parties were all engaged, and they were engaged heavily in the process of conducting the tests and examining solutions.
But then there was an extension granted, is that correct?
There was an extension of time for the comments.
For the comments.
Yes, absolutely, and it was all considered, and it resulted in the action that the agency took.
And refresh my memory, how long was the extension of the comment period?
I think it was...
It was 3 days.
Yeah. Again, I'm just a simple outside observer. That for an issue of this complexity did the parties who complained about the length of the comment period, were they mollified by a 3-day extension?
Excuse me, they did in fact file comments in the proceeding, and they came in and they had various meetings with us during that time, so there was plenty of time for them to meet and to give us their views on the proceeding.
Well, just, as an outside observer across the street, 3 days doesn't seem like a lot of time for an issue of this complexity. I appreciate the fact that it's been worked on for a long time, and a lot of people had much more working knowledge of this than I do. But it does seem condensed. What did they relate to you when you said, okay, you got 3 more days? Did they say, this is great, that's all we needed?
Well, what I recall is that they in fact did file within that period, and then they had plenty of time to come in before the waiver order was issued in January. So they had many weeks to come in. They took advantage of that time. We heard their concerns. In fact, as Mr. Knapp said, the action that we took direct consideration of what they had raised with us, and we basically stopped LightSquared from going forward with commercial deployment of its system until the interference concerns were resolved. Now, we did not resolve
those. Can I stop you
those.
for a second? I know my time's up, but it seems like the interference questions haven't been resolved even at this date. Am I understanding that correctly?
You are, and that's one reason why getting the process started as soon as possible was really important. We wanted to get that started and get all the parties together.
Thank you, Mr. Chairman. I appreciate the indulgence.
And the gentlelady from, Mr. Bilbray was here. I think Mr. Bilbray's next for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, let me first clarify, I've got a personal stake in this. Any one of us that go off into the ocean with our families offshore know how important the GPS is, not just for aircraft, not just for finding your way around streets, but basically, getting home and making sure you don't run into some rocks. But on the flip side, if I may say to the ranking member, just as much as the GPS is essential, there are thousands of people offshore every day that would have a huge safety factor if they could pull up their iPhone and from 200 miles offshore be able to call for emergency services. So this has a safety issue going from both ways. But I think this is much bigger issue than just GPS or a new access into the LightSquared. And if I could say to the ranking member, we need to recognize that this is setting the message across the country and around the world of exactly how the federal government is going to handle the situations. And if we do not straighten this out, the alternative is for us to have an intransigent, locked-in system that says, nope, we won't allow anyone to move outside of any arbitrary lines we make, because once you cross those lines, we know we can't get you back. And I'll give you an example, analogy. This is like somebody using a passing lane or going into the other lane to pass. We do that all over this country. But once you start allowing people to claim a right for using a right-of-way that was not set aside for them, the only alternative is to eventually, for the government to put up regulatory Jersey walls to where that option is no longer available in the future. Even though no one's using that lane 99% of the time, because we won't enforce it when somebody wants to use a lane, we've got to block it off, and that asset is not going to be used with flexibility. We're going to become intransigent bureaucratic lines. So I think that we've got to recognize this issue is very strongly setting an example to the next group that bids on something. Are we going to apply it and be flexible, and thus when the time comes, are we going to implement it, or are we going to create the barriers? Isn't this a situation of squatting and squatters' rights? And how do we tell anybody when they do bids that there's not going to be a squatter sitting on their spectrum if we don't straighten this thing out and make it clear to everybody that the federal government will make you whole and will not allow squatting to supersede the due process that we've set aside? How do we avoid that?
Well, first of all, as we conduct our processes, They're open, and it's incumbent on all the parties to participate in that. This situation has been, in my 38 years at the FCC, an anomaly. Almost invariably, the parties come in and explain.
Okay, when the parties explain this, let me interrupt one thing.
Yeah.
When they talk about interference, are you saying, wait a minute, is there interference, or is it harmful interference? There's one thing to have static with GPS. Mm-hmm. There's something else to be blocking the GPS. Isn't it true that the quote-unquote interference may not be harmful interference that would block the item? It may give some difficulty, will not, but still won't be able to block the service. The service still gets through with GPS. Isn't that true?
This is one of the issues that has been raised in our document, and it's one of the core issues that the Commission routinely has to address in deciding whether interference is harmful or not. We also have to take into account, when we're dealing with public safety services or defense, a much higher threshold for ensuring against problems.
Okay, there's the problem. We're now creating the issue of that we will go so far because we think it's a public safety issue. And if once you name that, as somebody that's run police departments and sheriff's departments, the question is, does that become now the excuse to use that lane all the time, even without a red light running, even though it's not a code 3? Because we're public safety, we get to drive in the left lane all the time without having to show that there was reasonable application here. And that's what I'm concerned about. And let me tell you something, someone's run police departments, that happens all the time, you know. But we don't sit there and continue to allow it just because somebody claims it. They need to prove it. And that's that harmful interference. When will you get that clarified? And what is your obligation to make sure that we make this whole so this Congress and future Congresses don't have to start building Jersey walls and blocking off all kinds of great flexible opportunities, because we've seen what happened with LightSquared, so we're not going to allow any flexibility in the future. How do we maintain that flexibility?
So this issue, I think, has given greater focus to receivers and the issue of staying in your lane. And we conducted a workshop at the Commission on addressing receiver standards going forward. Just this past March, we've tasked our Technological Advisory Committee, which includes experts across industry, to make recommendations on how we can deal with these kinds of issues in the future as we're making spectrum allocations. So we are working on it.
Thank you very much, Mr. Chairman. What he just told me is now they're going to be harder and put up Jersey, basically block it off, that flexibility, to avoid this problem. That's exactly what I want to avoid, and that's why we should be working to straighten this out so they don't have to start putting up those Jersey walls, and we maintain our flexibility. I think both sides want that. I yield back.
I thank the gentleman for his insight. And the gentlelady from Tennessee, Ms. Blackburn's recognized for 5 minutes.
And thank you. And Mr. Chairman, I do want to take a moment and just thank you for your leadership. You're going to be missed. We're all going to miss you and appreciate the leadership and guidance you have given this committee on so many issues. To our witnesses, we're going to have votes called in just a few minutes, and I want everyone to have the opportunity to get through their questions. I want to talk with you specifically about your February 10th memo, and or it's an email from February 10th and the March 26th, 2010 order dealing with preventing Skyterra from making its ATC spectrum available to AT&T and Verizon. So let's start, Ms. Delatorre, with you, with that February 10th email from Joel Rabinovich. You're on that email, correct? You're a recipient of that. It's Exhibit 9 in your binder. Would you please speak into the microphone?
Yes, I am on that email, but I wasn't participating in the email as far as responding to it. I am on it, though. Okay, but you read in there that, and I'm quoting from the email, the condition is that Harbinger not sell to Verizon and AT&T. So is this email consistent with your thoughts regarding the purposes of the conditions? Thank you, Congresswoman. In fact, the where we ended up was not where the email started, actually. We ended up, there was a loophole in the FCC's sort of framework for secondary markets of spectrum. And terrestrial systems at the time could use secondary markets and they could lease their spectrum. But MSS operators could not. And so one of the reasons that we had wanted to put this condition in on AT&T and Verizon, it didn't prohibit them from actually gaining access to that spectrum, but it said that the FCC needed to be notified of that. And I think that that just basically filled in a gap in our rules that we then actually changed the rules later in the following year in April 2011 to apply it to the mobile satellite service as well. So AT&T and Verizon, just to be clear, were not prevented from actually accessing that spectrum. They just had to give notification of that.
Okay, well, let me ask you this then. Do you think it should be common practice for the FCC to impose conditions like this when it really, so that it affects the rights of non-parties to a proceeding? Should that be common practice of the FCC? Should they move forward in that vein?
I've been at the Commission for 3 years, and during that time, in most of the transactions that we've worked on, we have conditions that are applied, and they are specific to the particular transaction, and I think that's what we did here as well.
Okay. Let's talk about Global Star for a second. I've got a couple of questions I wanted to ask that. On June 30th, 2010, the FCC granted Global Star an extension of its deadline to come into compliance with the ATC gating criteria until August 2nd of 2010. Despite the fact that the FCC granted Global Star's 30-day extension, the RUS suspended Open Range's future loan advances on July 14th, 2010, and threatened to suspend its remaining funds unless it found an alternative spectrum partner. So during this period, were there any conversations between the FCC and RUS or the FCC and the White House discussing the possibility that LightSquared could serve as an alternative spectrum partner to Open Range?
Thank you, Congresswoman. I was not a party to any of those conversations. If they were held, I was not a party to them.
Were you aware that there were any? Mr. Knapp, you want to respond to that? Pardon me?
Neither was I.
Okay. You were not a party to them, or you were not aware that they were taking place?
I was not aware that they were taking place.
Okay. Pardon me, Ms. Della Torre?
Is it either one?
Either one.
Right.
Okay. Thank you. My time's expired. I'll yield back.
Thank you, gentlelady. And the gentleman from Virginia, Mr. Griffith, is recognized for 5 minutes.
Thank you, Mr. Chairman. Let me echo the comments of my colleagues on how much I, particularly as a freshman, have appreciated your leadership, and I have learned a great deal from you. And I'm kind of hopeful we'll have some more hearings. But in the event that we don't, let me add my comments to those of my colleagues and how greatly I appreciate your leadership. Thank you. That being said, if I might ask, how does the FCC define harmful interference? And let me do some subparts on that. Is the level of harmful interference specific to each GPS device, or is there a particular industry standard that defines whether interference is harmful? Is any interference harmful? Who makes the decision at what level it's harmful? Is that the FCC, or is that the GPS device manufacturer or user? And is the design of the receiver relevant to the determination of harmful interference? And I'd be happy to repeat the subparts if you need me to. But the base question is, how do you determine harmful interference, and who makes those decisions?
First, I'd be more than happy to provide the precise language of the definition in the Commission's rules. It's consistent with the international definition. It generally, in lay terms, is it's subjective. It talks about repeated disruption of a service, particularly in the context of safety and navigation services as well. So the definition itself gives deference to the importance of protecting safety services. In the case of GPS, there are multiple kinds of receivers. So in some instances, there are industry standards. So, for example, for the GPS chips that are used in cell phones for 911 location, there are industry standards that are in place. As commented, I think, in the letter we received forwarding the test results from NTIA, there is no accepted standard for general navigation equipment. There is a standard for aeronautical, and so I'll stop there. So in some cases there are standards and others not, and the criteria for determining what's harmful are not always consistent. Was there a question I missed?
Yeah. Okay. How is the filter design relevant to that, if they can
So
or shift?
filter design comes into play usually at the intersection between two adjacent bands. So it's not unusual to have some play, some flexibility between the surfaces right at the borders. And normally those problems are solved between the parties themselves. We have to look at the overall characteristics of the equipment in a service and what it's capable of doing in making decisions like this as to what's harmful or not.
All right. You know, and this is one that has always got to bother you. And for centuries, the law has tried to figure out on different items how to make this work. But the FCC has relied on the fact that no party raised the overload interference issue until late 2010 to account for its late consideration by the FCC. And I have to ask, you know, what standards of timeliness does the FCC have? I mean, oftentimes if you don't raise an objection in other areas of the law, you lose them. And whether it's a statute of limitations or the theory of latches, you've got a timeliness issue. So what's the FCC's rule on that?
So we're governed by the public interest standard. And in this case, although it's a very difficult situation, we cannot put at risk things like air safety or defense or 911 systems and so forth. So we have to be very careful when we evaluate those kinds of situations.
All right. Mr. Chairman, I have no further questions at this time and yield back.
Thank you, gentlemen. I think what we're going to do is I'm going to have a second round, and the ranking member has a very short question too, and then we'll adjourn the committee. So my question is to Mr. Knapp. You know, obviously a company has lost $4 billion, a huge amount of money. The technology it had was a game changer. The whole thing has been scuttled, and so what we're trying to do now is understand what solutions are available. So, Mr. Knapp, the Technical Working Group and the PNT XCOM both conducted interference testing on multiple types of GPS devices. Is that correct? Yes or no?
Yes.
Okay. How many different types of GPS receivers did the Technical Working Group actually test?
They tested a pretty significant number of each different type. And, so for cell phones, for example, and for the personal navigation devices, I believe it was well over 75 or so.
75, okay. How many different types of GPS receivers did the PNT XCOM test?
As broad categories, I believe there were 6 or 7 different categories.
Okay. In the Technical Working Group testing, what types of GPS devices were deemed susceptible to harmful overload interference?
So the report from NTIA commented that the cell phones, well, for any device, if they get close enough, you can have interference, that the cell phones appeared to be okay. There was concern that 75% of the, and I'm just reciting what the report said, 75% of the what are called the general navigation devices.
Right.
In the case of aeronautical, the judgment was against an industry standard.
Were there certain types of GPS receivers that did not receive harmful interference from LightSquared signal? Yes or no?
Yes.
Okay. What standard was used to determine harmful interference in the Technical Working Group's testing?
So there were different standards for each of the different working groups. In the case of cell phones, they used the worldwide standards developed by a group called the 3GPP, which is Third Generation Partnership. There were no standards for general navigation. They use a standard for the aeronautical equipment based on the radio technical.
What's with the FCC's responsibility to oversee the working group?
So in this case, we did what we often do. We brought all of the parties together through this process with the obligation.
So you're a facilitator and not much more?
Yeah, and
you're not an investigator, oversighter, or an enforcer?
Well, part of the rationale here is we want to be careful not to steer the work of the group, because in the end we may have to make a decision and assess its work.
I understand. Who provided the devices for the technical working group testing?
That came from the working group itself, which was co-chaired by the GPS industry and LightSquared.
In the PNT XCOM testing, what types of receivers were deemed susceptible to harmful overload interference?
So just to be clear, there was a first round of testing, and there in the second round, all that was looked at was cell phones and general navigation devices, and then a particular class of aeronautical equipment that was used for mapping terrain.
I think I've asked this before, but certain types of GPS receivers, weren't some of them did not receive harmful interference from LightSquared? In other words, isn't it true some of them did not?
Yes.
Isn't that true? Would you say there are a lot of receivers that did not receive it, or was it significant? Would you say significant?
It varied across the categories, and one of the categories that was particularly not covered in the second round, it was called high precision equipment, and that's some of the equipment that is designed actually to operate across both bands together.
If harmful interference was not observed in a particular category of GPS devices, does that mean a potential solution might exist for that category?
Well, for the equipment that didn't experience harmful interference, there's a solution for that category.
In your mind's eye, can this problem be solved?
I think the...
just yes or no.
I can't answer yes or no, because just as when we went into this, until you work through the problem, you don't know the answer.
Well, describe what your solution would be.
I can't describe what my solution would be. I know that there are ideas that are on the table that we're considering.
And do you endorse any of those ideas?
No, we have an open proceeding. It would prejudice the outcome for me to endorse one or the other.
Well, as an electrical engineer, don't you think this could be solved?
As an electrical engineer, we always strive to solve the problem, but there's no certainty that you're going to get a
You got to pass the exam. It's either yes or no. All right. Well, as I say, I think all of us are a little frustrated with this huge possible innovation leap here in the loss of this company, and so anyway, my time's expired.
Mr. Chairman, first of all, I'd like to ask unanimous consent to put the spectrum chart into the record, which I had shared with your staff.
Oh. By unanimous consent.
Thank you.
Made part of the record.
And I also understand that you're going to put the exhibit notebook into the record, subject to some redactions that will be agreed upon.
That's
by
correct.
staff.
That's correct.
I would just ask unanimous consent that we put Ms. De La Torre's memo, Exhibit 1, in the exhibit book in without redaction.
Unanimous consent, so ordered.
Thank you very much. I just want to say I don't have any questions. You'll be happy to know, but I just want to say that this entire hearing really highlights the urgency of the work that the Select Working Group that Chairman Upton put together, and which I was privileged to serve, a subcommittee, a select subcommittee of this full committee, because as we look more and more at the use of spectrum, and as we look at increasing demands on our spectrum, we're really going to have to figure out how we balance really important, legitimate commercial needs, like in this situation with LightSquared, with GPS and other security needs and so on. And I think that work that the Select Working Group has been doing throughout the spring, summer, and fall has real urgency, and I'm sure that the FCC would agree with that. And Mr. Chairman, I look forward to working in the next in the next session of Congress on both sides of the aisle to start to figure out what we do with some of these issues, because unfortunately, I think it was Mr. Knapp who said that in his 30-plus years at the agency, he hasn't seen a situation like this. But I think everybody would agree if we can't start to think about what we're doing with our spectrum, we're going to see more and more situations and more demands bumping up against each other. I see both of our witnesses nodding their heads yes. So thank you for having this hearing, and I look forward to continuing to work.
I thank the gentlelady and thank the witnesses for their testimony this morning. In conclusion, I'd like to thank all of the members for staying here. I remind members they have 10 business days to submit questions for the record, and I ask the witnesses all agree to promptly respond to these questions. And with that, this is my last hearing as a member of Congress, and I just want to thank the members on both sides for their participation, and more importantly, the staff. The staff's done a great job throughout my tenure as chairman of the Oversight Committee, and I appreciate all their hard work. With that, the subcommittee is adjourned.